Please proceed, Ms. Higgins.
I'm grateful, Your Honour. As Your Honour has received 3 filings in this matter, it is clear, I'm sure, to Your Honours by now, that it is the defence position that the heart of the submission that we make in respect of both the report and the film concerns its unreliability, which we say goes directly to the admissibility point and not the weight as has been submitted by the prosecution. Support for this principle can be found in paragraph 9 of the Milutinovic decision of the 1st of September 2006, which refers there to the fact that although certain earlier decisions of the tribunal held that reliability is not a precondition for the admission of evidence, the text of the rules and more recent appellate jurisprudence makes it clear that reliability is relevant to the admissibility of the evidence, particularly where that evidence concerns an out-of-court written statement. Your Honour, we also rely upon not only that decision but the second Milutinovic decision of the 13th of September 2006, which we've cited in the motion, and we submit that those decisions are on all fours with the challenge that faces this trial chamber in determining the unreliability/admissibility aspect of the matters before you. In paragraph 6, to address the reply specifically, the Milutinovic approach to admissibility has been described by the prosecution as the exception rather than the rule. I would stress, however, Your Honour, that it has come to my attention within the last few days that the decision is not one which is only relied upon by the Cermak defence before this institution. It's also one which stretches to be pleaded before the Special Court of Sierra Leone in the Charles Taylor case, where a motion is pending before that court, submitted on the 5th of January 2009, relying on the Milutinovic approach concerning the admissibility of similar NGO reports. To deal briefly with several of the points that have been raised, I would draw Your Honour's attention to paragraph 3 of the prosecution's reply, where, in my submission, a narrow selection of factors to be taken into account when dealing with admissibility has been put forward. 6 of the key factors, again rooted in Milutinovic, are not set out, and Your Honour has these in the defence motion that has been filed before the court. I don't intend to repeat them here as they are clearly set out. Paragraph 7 of the prosecution's reply refers to the fact that this trial chamber has admitted documents previously concerning first and second-hand hearsay, and the reference there is to the admission of documents tendered through the UNCIV-POL witness, Mr. Jan Ellaby. Your Honour, in my submission, the difference here is that it's not just a matter of first or second-hand hearsay, but you are confronted by 10 pages, as set out in the defence motion, of live indicators of unreliability. Not only are the interviewers not named, but in many instances the interviewees are listed by initial only, and in many cases, as I have sought to demonstrate through the filing of the motion, there are no footnotes at all.